The appellant may proceed.
May it please the Court. My name is Latasha Garrison Fullwood. I am serving as counsel for the appellant, Stacey Craven. I'm with the law firm of Taylor Day, Curry, Boyd & Johnson in Jacksonville, Florida. I'd like to reserve 3 minutes for rebuttal, please. This is an unemployment case where our client, Stacey Craven, was denied unemployment benefits. At the heart of this case is whether or not Ms. Craven left her employment on September 23, 2009 as a result of good cause attributable to the employer. It's our position here that the commission incorrectly ruled that she was not entitled to benefits and that she did not leave her employment for good cause.
If she had waited 2 more weeks until her contract expired, would she have then qualified for unemployment benefits, regardless of what was going on and anything else, if she just sat there for 2 more weeks?
It's our position that she would have. But at the time that she left her employment on September 23, 2009, she also left for good cause.
Wonder if they had, she in essence left within days of them starting, or the day they, right?
The day after they started an investigation.
So if she had left a month after, would that be okay? I'm just wondering so the fact that they started the investigation in your argument is totally irrelevant.
I'm sorry?
The fact that they had started an investigation in your argument is totally irrelevant.
Correct.
It wouldn't matter when she left. Once, I guess she went in, July? She initially told the... In
July 2008, over a year before her employment actually ended.
And at that time, she requested no further action.
In July 2008, she had a meeting with Kurt Molander, who was the general manager, meaning that he absolutely managed this television station. She had a meeting with him. She explained to him that she was the victim of sexual harassment. She did not tell him the name of the harasser at that particular time. However, 2 months later, she did report the name of the harasser to Tom Lewis, who was the news director.
Okay, isn't that the key really here to the whole thing?
Right, that is the key.
The conversation with Tom Lewis, the news director?
Correct.
And it comes down to, in my mind, whether at that point the station had a duty to go forward with some kind of investigation or action at that point.
And it's our position that they absolutely did. There is absolutely no information in the record. There's no testimony that she told Tom Lewis not to pursue an investigation. And in fact, when she went to Tom Lewis...
Okay, was there any other than your client's testimony, was there any other testimony concerning that conversation that took place?
No, they did not. The appellee did not have Tom Lewis testify at the hearing.
Okay. She had been told by Mr. Moreland, which was found by the hearing officer, that she was told that she had to report anything further to HR. So address the question of whether her conversation with Mr. Lewis created a duty on the part of the station, because it seems to me this is a significant question. When I tell an employee to follow a certain reporting requirement as a station, can I expect that they have to do that?
According to the testimony in the record, the sexual harassment policy specifically said that she could report either to a supervisor or to a manager. Tom Lewis was, in fact, her manager. In fact, she reported to Mr. Kelly, who was the director. He's the chief meteorologist, so, of course, she didn't want to report to him. She went to Tom Lewis, who was, in fact, her manager, and he told her not to tell anyone. That is the testimony that is contained in the record.
Okay. The only question is, can I read the hearing officer's – I'm sure there are other questions, but the one I want to ask. Can I read the hearing officer's order where he said that she, never told them until
August 2009 is what?
2009, as impliedly rejecting her testimony as to her conversation with Mr. Lewis?
No, I think that it was just an absolute incorrect date.
What's her obligations? She's the victim of sexual harassment, and it's her obligation under the unemployment comp law to take all steps to maintain her employment, correct?
It is her responsibility to attempt to maintain her employment. However, there are multiple cases, such as Yulo and Yeager, where an employee actually reported sexual harassment and ultimately left their employment, and they were granted unemployment benefits.
So what we have here, though, is she chooses Mr. Molander as the person she reports to. From the record, it seems as though he treats it very seriously, regardless of what Mr. Lewis may do. I mean, Mr. Molander meets with her. She says she doesn't want to identify. She signs a form saying she doesn't wish to identify. And at that point, Mr. Molander tells her to go to HR if there's any more incidents. And then she basically talks to Mr. Lewis, and she talks to Mr. Lewis for, if I understand it correctly, several times over the course of the next year, right? I mean, it's almost like an ongoing conversation with Mr. Lewis. She doesn't go back to Mr. Molander, because as soon as Mr. Molander finds out, he doesn't start the investigation.
No, that's not correct. Mr. Molander testified that he at least knew about the identity of the sexual harasser, Mr. Kelly, by April of 2009, which was 5 months before she actually left employment. There's also testimony in the record that after he found out that she sent him, that he was in fact the person, or Mr. Kelly was in fact the person that sent her a picture of his genitalia and who was sexually harassing her, he never disciplined Mr. Kelly. And as the general manager of that organization, it's our position that he had an absolute responsibility to contact human resources, and later on an individual from the Tallahassee station named Nick Waller came in and conducted an investigation in September 2009, but that was only after counsel, Ms. Craven's counsel, had sent a letter to Gray Television. From September 2008 until September 2009, there was absolutely no investigation done. There was no disciplining of Mr. Kelly, and nothing done to make sure that she was in a safe environment.
But people in authority at the station knew.
They absolutely knew. And there's also testimony from Ms. Craven that Mr. Lewis told her that he told that Mr. Lewis gave the information that they talked about to Mr. Molander. So there's record evidence that there were conversations between Mr. Lewis and Mr. Molander about Ms. Craven's reports.
Okay. Counsel, let's assume we agree with your arguments. Is the appropriate remedy here to reverse for awarding of the unemployment compensation benefits, or would the appropriate remedy be to remand for the lack of factual findings? It seems to me, you know, one of my concerns here is there's some critical issues that you're talking about concerning your client's conversation with Mr. Lewis that was never ruled on as far as factual findings. So would the appropriate remedy be to remand it back for factual findings at this point?
No, I would disagree with that, Your Honor. On page 168 of the record, the referee states the claimant ultimately divulged the identity of her harasser in August of 2009. That is just simply incorrect. It's not supported by anything in the record. In fact, there is no discussion about the August 2009 date as being a time frame where she reported the harasser. The letter that came from her counsel was actually in September 2009. The August 2009 date, in my review of the record, might have come from the time frame when she was terminated.
Might have. It seems to me that you're asking us to engage in supposition. So wouldn't it be safer on our part if we buy off on your arguments to send it back so we can really know what the hearing officer found, what factual findings there are?
It's our position that the hearing officer had the date incorrect. And so as a result of either, his inability to clearly understand the record or whatever the case may be, he had the information in front of him. There's nothing that needs to be supplemented. The information was available. It's in the record. It's in the transcript. There is no debate about when she reported this incident. It's clearly stated on page 86 of the record, line 15. The appeals referee asked, do you mean it was a year from the time you identified the culprit until they started an investigation? Ms. Craven states yes. On the record at 81 and 82, line 5, it says, did you at some point, some later point advise Mr. Molander who the culprit was? Ms. Craven states.
Well, let me ask you, would the hearing officer be required to accept her testimony, or could the hearing officer in the order have said, because she did not report to the HR department, I do not find her testimony concerning her conversations with Mr. Lewis to be credible?
In the absence of competent, substantial evidence to the contrary, yes, the referee would be required to accept Ms. Craven's testimony.
Really? That's interesting. If there is somehow a finding that would lead me to believe that the test, the evidence that this person's presenting might not be totally accurate, I'm required to accept that?
There is no competent, substantial evidence refuting that. The appellee had the ability, they were represented by counsel during the course of this unemployment hearing, they had the ability to present information or testimony to refute Ms. Craven's testimony, and they failed to do that.
Do they owe any deference to her wishes?
I'm sorry?
Do they owe any deference to her wishes? When she first went to Mr. Molander, Mr. Molander said, if you won't tell me who it is, I'm going to call every guy in here. We're going to have an investigation. I mean, do they owe any deference to her wishes not to proceed further?
I would say not. I would say that the station has the absolute responsibility to protect all of its employees and make sure that they are in an environment that is free from sexual harassment. However, of course, that's Gray Television's, of course, that's their business decision.
So if she went to see Mr. Molander and said, I am being sexually harassed, I'm not going to tell you who it is, and I'm quitting, would she be entitled to unemployment compensation? Would she have done everything she reasonably could to maintain her job?
I believe she would have. Because she has been subjected to sexual harassment over a period of time. And I want to go back to the September 23rd, 2009 date. She just didn't arbitrarily quit. At the time that she resigned from her employment, she specifically told one of her coworkers that she was leaking fluids. She was pregnant at the time. She was leaking amniotic fluids, and that's why she then left. The stress of the sexual harassment and the things that were going on at that point, she no longer felt that it was appropriate for her to be in that environment. And it wasn't, of course, she didn't subject herself to that environment. And Gray Television, they are the employer. It's their work environment. They are the ones who are responsible for making sure that their employees are in a safe, sexual harassment-free work environment.
Okay,
so
you're into your rebuttable time. I just want to let you know.
I'm done.
Good morning, Your Honors. May it please the Court, Rebecca Shanlever from Troutman Sanders in Atlanta. I have with me at council table Mr. Kurt Molander from the station in Panama City. This is Kurt Molander from the station in Panama City. This case is not about whether Stacey Craven was sexually harassed. That question is for another forum. It's not about when the station learned that she was having harassment.
Why not?
It actually is.
Why not?
That's exactly what it's about.
It's about whether at the time she quit on September 23rd, the morning of September 23rd, 2009, over a year after she met with Mr. Molander and first told her about the inappropriate comments. It's whether at that time, on the morning of September 23rd, 2009, at that time she had good cause to quit her employment.
Well, if we believe her testimony about her conversation with Mr. Lewis, she had to put up with this behavior for a year more, and Mr. Lewis told her to keep her mouth shut.
Actually,
so why?
Actually, there was no testimony from Ms. Craven at the hearing that anything further had happened since the early 2008 comments that she reported to Mr. Molander in July 2008.
Didn't she say she didn't want to go on a trip with Mr. Kelly at some point?
She did, and we honored that request just like we honored her request not to do anything about the complaints that she was bringing to Mr. Molander. We did. This is not a case where the employer was insensitive to her concerns.
Was there testimony in the record that the harasser had harassed somebody else at the station?
No, there was testimony from Ms. Craven that Mr. Lewis, the news director, told her that someone from outside the station had sent a photograph to the station claiming that it was this alleged harasser, a picture of him. And he went to Ms. Craven. Ms. Craven didn't go to Mr. Lewis and complain about further harassment. He went to her and said, can you send me a copy of that picture again? We want to see if this is the same picture.
Okay, but it seems to me, as I read the hearing officer's order, basically he was saying, well, she did not give them sufficient time to deal with the problem. Therefore, it was not good cause attributable to the employer.
Well, one of you asked a question earlier. I think it was Judge Hawks. Would she have had good cause to quit back when the harassment was happening in early 2008 or even in July 2008 when she spoke to Mr. Lewis again? And I don't disagree. Maybe she would have had good cause at that time. But when you fast forward to September 20th.
But isn't forcing you to work with a person that sends you a picture of their genitals, isn't that good cause? I mean, I can handle it for 2 weeks, but if the station is going to continually not do something, couldn't a hearing officer have found that that was good cause?
The hearing officer could have found that if those were the facts, but those weren't the facts, and that's not what the
picture didn't come after she talked to Mr. Molander?
I'm sorry?
I thought the picture was sent to her after she had spoken.
No, sir. The picture was sent in early 2008 was her testimony. She didn't go to Mr. Molander. He met with her in July 2008 like he met with all the other employees of the station when he started at the station. During that meeting, months later, she said it was March 2008 when she got the picture. In July, she tells Mr. Molander about the picture that had been sent in March. Nothing else had happened during that time frame. And the only thing that happened by September 2009 is that she had been told her contract wasn't going to be renewed, and her lawyer had sent a letter outlining additional facts that hadn't been.
When did the conversation about
and we'd start our investigation.
The pregnancy, I dig pregnant women.
That was the only comment that happened between the time she spoke with Mr. Molander in July 2008 and the time that she quit in September 2009. One comment.
When did that comment take place?
That was in May of 2009 when she announced her pregnancy.
I mean, Mr. Lewis, is the station completely exempt from everything that Mr. Lewis knows and not responsible for anything Mr. Lewis says, and she has no right to think that maybe Mr. Lewis will take responsible action or anything? I mean,
absolutely not. I mean, Mr. Lewis didn't testify at the hearing. We know what Ms. Craven testified to at the hearing about her conversation.
So let's accept that conversation as being true for right now.
Sure. And that happened. The problem is, Your Honors, that conversation happened in May of 2009 when she had her pregnancy.
So
when
she
announced her pregnancy. She worked
she
with no problems from May until September.
Okay, but if she'd left 6 weeks after her conversation with Mr. Lewis, would she be entitled to an unemployment compensation?
It depends on what happened that day. If she had experienced another sexually harassing comment such that there was good cause for her to leave at that time.
Wait a second. Oh, she comes in, though, and now is willing to identify this person. She hadn't been willing to identify it, but if you believe the conversation, she's now identified the person. So isn't it reasonable for the station to assume at that point she's willing to go forward and do something, even if she's not willing to go forward? If she had waited 6 weeks after Mr. Lewis's conversation and at that point said, they're not doing anything, I'm out of here, would she be entitled to unemployment compensation?
Which conversation with Mr. Lewis are you talking about?
I'm talking about the one where she gave the picture and
where she showed him the picture and
identified who had sent it to. Yeah.
That was in July of 2008.
Okay, but
no, excuse me. That was, I apologize. That's wrong. That's when she talked to Mr. Molander. She talked to Mr.
Wasn't
Lewis.
it September or something like that?
In September of 2008. That's correct.
Okay, so let's say
she
quit.
Let's
say she quit. Just asking you to make assumptions.
Okay.
Nobody wants me to have me make assumptions this morning. If she had left in November of 2009, or 2008, excuse me, would she be entitled to unemployment compensation benefits?
Possibly.
Okay.
I mean, because,
Sure.
One way I look at this is she goes to see Mr. Molander, and Mr. Molander, at least from the record, appears to have treated it seriously and respects her wishes. And then she goes to Mr. Lewis, and Mr. Lewis's comments seem dramatically different than Mr. Molander's comments. Mr. Lewis's comments seem to be, oh, that jerk, I can't believe he would do that. I mean, but nothing like, we're going to help you, we'll investigate, we'll protect you, so I think if Judge Wolf's question was, if she has this conversation with Mr. Lewis in September of 2008, a few weeks go by, nothing happens, could she have left her employment saying, this is just not a comfortable place to work, and they're not going to help me?
You have a good point. Nothing had happened. The action that Mr. Molander had taken was effective until May 2009. There's no further inappropriate
remarks. Is she allowed to change her mind? In other words, when she first talks to Mr. Molander, I guess you said he just started at the company, maybe she doesn't know him. She makes this comment, she's not sure, maybe things will just work out without. Is she ever allowed to change her mind and say, I would like to see something happen?
Sure.
Granted,
in
July,
but
now it's September.
And tell him, I want something done.
But does she have to go to Mr. Molander? She can't go to Mr. Lewis? Was Mr. Lewis her supervisor?
Mr. Lewis, she reported directly to Mr. Lewis, but Mr. Molander was her ultimate supervisor and the decision maker with respect to the non-renewal of her contract. But to answer your question, she never told Mr. Lewis, I want something done. She showed him a copy of the picture.
How far does she have to go with that?
Once she says, I don't want anything done, I think she has to then affirmatively state, no, I do want something.
But what responsibility? Doesn't the employer have a responsibility to ensure that the workplace for everyone is free of sexual harassment? So even if she says at some point, look, I don't want y'all to investigate this because I don't want the retaliation, which is, okay, and the company sort of agree to that. But then she finally tells someone in authority, look, this is what's happening. She has more than one conversation with that person in authority about this. At what point does the employer now have the responsibility to go, okay, we now know who this is. We have to do something about this. Even if she says, I don't want you to investigate this, doesn't the employer have a responsibility to her and to its other employees to do something of its own accord?
We did begin an investigation. When she quit, on the day that she quit, we were in the middle. It was less than 24 hours of when we had begun a full investigation at her request. Certainly, I don't disagree that the company does have some obligation at some point to begin an investigation. But that's not what's at issue here. The referee found that, and the Unemployment Appeals Commission hit the nail on the head when they said that there's ample record evidence to support the material findings a fact that the referee relied on in making his conclusion. We don't disagree that there was a mistake apparently about the date when she first identified the harasser, this August 2008.
But is it a fair reading to say that of the referee's order that she did not give them time to conduct an investigation? I mean, is that a fair reading of his order?
That's exactly what he says. I don't
okay,
think
no, I know that.
I think that is a fair reading.
But does that not fly in the face of him not addressing Mr. Lewis's conversation in his order?
No, because the day that the relevant inquiry is what was the environment on the day that she quit. And on the day that she quit, we were in the middle of our investigation. She walked out of work without telling anybody in management, just left in the middle of her shift. When we inquired about whether she was going to come back to work, she said, no, I'm not coming back at all. She never said, I fear retaliation. She never said, I'm concerned about, she just said, I'm not coming back to work. And we did the best we could with the investigation, which after we had spoken with her and what we could find out, and we did the only, we felt like,
assuming the conversation with Mr. Lewis took place, do you really think you did the best? You can really say you did the best with the information you had available?
And if she had quit at that time, it might be relevant. But
okay,
it's not
so
material.
I guess your argument comes down to that at some point her good cause evaporated.
When she continued to work with no further comments and
Okay, and if we don't buy that, the fact that her good cause evaporated, again, making assumptions that I don't want you to make, doesn't the question of the conversation with Mr. Lewis become critical, and shouldn't the hearing officer can't talk this morning, shouldn't the hearing officer address that?
No, because, again, it's not that good cause evaporated or didn't evaporate, but the conversation with Mr. Lewis, according to Ms. Craven, happened well over a year before she actually quit in September. So the conversation with Mr. Lewis is relevant.
It shouldn't. No, I disagree. If indeed, first of all, the referee found that the claimant ultimately divulged the identity of her harasser in August 2009, one could argue, and I think the claimant's position is that that finding is not supported by competent substantial evidence because she ultimately divulged the identity of her harasser in September 2008 when she had the conversation with Mr. Lewis. So
we don't disagree.
But let's just, okay. So if that is really the correct finding, then that finding goes to whether or not the employer then had a reasonable opportunity to cure the problem. That's the relevance of that date.
If she had quit on that date,
it doesn't matter. Just because she didn't quit immediately, she, according to the legal conclusion that the referee and the UAC made, if she told the employer the identity of her harasser in September of 2008, she didn't necessarily have to quit that day, because then the employer would not have had a reasonable opportunity to cure the problem.
So she just gets to continue to work until she decides, okay, now I'm going to quit, without giving us.
Well, if the hearing officer had made a finding that there was some ulterior motive for her quitting and that was really not the reason, the hostile work environment, then I think you have a better case, at least.
Her obligation is to attempt to maintain her employment. And it just seems to me that if we look at everything, I mean, she did go to Mr. Lewis, and Mr. Lewis comes back to her, and she has to reproduce his picture again, which I would assume isn't, and then she hears the reason she has to is because perhaps he's sending it off to other people as well, for whatever reason. And then she does start to have complications with her pregnancy, which might be very scary. And she's thinking, I'm not going to jeopardize my pregnancy. I got 2 weeks left anyway. It's just not working. Doesn't that justify her leaving? I mean, if that's the way the facts are interpreted by the hearing officer?
Reasonable steps would include letting us know that there was some problem with her pregnancy. She didn't do that. She just walked off the job, didn't ask for medical leave, didn't
I read all of Mr. Lewis's comments, if they're true. All of Mr. Lewis's comments as to be really cavalier and not at all responsive to her needs. I mean,
but we had someone else already coming in. We were in the middle of our investigation on the day that she quit. I'd like to also just briefly, because I'm running out of time, remind the court about once the investigation was completed, that it did boil down to a he said, she said type situation that often happens with these things. So this company did what they thought was the right thing to do, which is to offer Ms. Craven her job back. Mr. Kelly, the alleged harasser, was gone, and she knew that, and we offered her her job back, and she didn't even give us the courtesy of a response.
Okay, well, would she have been entitled to unemployment compensation benefits up to the point that the company offered her job back?
Assuming that we go back and have further factual findings, then yes.
Okay, so then we still have to reverse. We still have to reverse it. But
correct.
The issue of whether she,
correct. But at the latest, her benefits would be over. Assuming she is entitled to benefits and had good cause to leave on September 23rd, 2009, they would be cut off as of the day she rejected the unconditional offer to return to suitable work.
Okay, thank you.
I want to go back to the question that was asked Did Gray do the best that they could with the information that they had? And they absolutely did not. It took them an entire year to start an investigation, and it was only after attorneys got involved and a letter was sent directly to Gray. Tom Lewis ignored her complaints, did absolutely nothing about it. When Kurt Molander found out about the harassment at least 5 months before.
Well, I mean, do we have to you know, assume that her statements to Mr. Lewis were complaints? I mean, could they have been a conversation about past history of things that happened at work?
No, these were actually complaints. And as a matter of fact, in May 2009, immediately the day after he.
But isn't that a decision that the hearing officer makes? I mean, you know, there's one thing to tell someone about this experience you've had, reporting, and there's another aspect about attempting to complain. You know, obviously she did know to go to Mr. Molander in the beginning. Evidently, Mr. Molander told her to go to HR. I mean, so, you know, and so on her own, she goes to Mr. Lewis. One way could be maybe I feel more comfortable reporting and complaining to Mr. Lewis. Another one could be he's just a colleague and a friend, and I share information with him, and it wasn't expecting anything formal to be done. And it just seems like the company's responsibility would be different depending upon which avenue she were taking.
I would disagree with that. I believe that the company's responsibility is to make sure that she's in a safe environment. And if an employee goes to their supervisor, manager, and complains about sexual harassment, they absolutely have a responsibility to do something about it. Mr. Molander testified that he didn't even discipline Mr. Kelly when he found out that he was, in fact, the harasser, and he'd sent this picture of his genitalia. But I also want to go back and address the issue that the appellees raised regarding this conditional offer of employment. First of all, the letter was sent, I believe, sometime in October 2009. At that particular point, there was testimony from Kurt Molander that they had actually hired somebody to fill her position. So I'm not really sure if we can even say that that was a real offer of employment.
But I don't think we can say anything about that. I mean, to my knowledge, that was not among the findings of the referee. So even if were that to become relevant, that would be, you know, something that we would have to remand it back to the hearing officer to make findings on. So
I agree, Your Honor. That was not an issue that the hearing officer addressed.
Okay, your time is run. Thank you, both sides, for a well-argued case.
Thank you, Your Honor.
Okay.